And good morning, everyone, and a very warm welcome to the second seminar in our Healthy, Safe, Productive Educational series. Now, today's webinar topic is Balancing the Pendulum, how to strike the right balance between employers' and workers' rights and responsibilities for workplace health and safety and wellness. Now, as a manager or business owner, you'll know that your business has responsibilities to provide a safe workplace, but you'll also know how much you rely on your staff and workers to work safely and be fit for the work that they are employed for. And there are times, though, when this balance can be tipped. So having a clear understanding of an employer and workers' responsibilities and rights for a safe and healthy workplace is critical for a business to manage one of its greatest assets, but also its potential costs, and that's its workers. So judging from the interest we've had in today's webinar, there's a lot of companies across a range of industries who are really grappling with how to get this balance right. So let's make a start. So firstly, having a lawyer in the room, we better start with our disclaimer. So if you just take a moment to have a read of that, and then we will certainly get going. And just before we start, I'd just like to give a big shout out to our series partner and supporter for the Healthy, Safe, Productive series, and that's Business Depot. Now, for those who don't know Business Depot, they're a full-service business advisory firm who are on a mission to help passionate individuals and businesses reach their potential. And accounting just happens to be one way that they do that. And the Healthy, Safe, Productive series forms part of their Depot Extra series, which is an expanded version of their hugely successful Depot X series. Now, this regular series features presentations from a range of industry experts, from digital media through to outsourcing through to OC Health and Safety. So to find out more, please just jump on their website. So as far as the Healthy, Safe, Productive series, we know that a safe and healthy workplace is critical for organisations to perform at their best. But we also know that many small to medium businesses particularly feel overwhelmed when it comes to tackling health, safety and wellness within the workplace. Now, this probably isn't helped by a limited budget, by often overextended staff and a lack of in-house expertise. And often it's probably just one more thing on their must-do list. But we also know where workers' health and safety fails that there are significant consequences, not just for workers, but also the business. So in recognition of these challenges, Kitney OHS and ourselves, Wellness Designs, supported by Business Depot, have developed an innovative educational series for small to medium business Healthy, Safe, Productive. Now, this four-part series kick-started on the 22nd of October and will consist of a series of breakfast seminars and webinars into 2016. And the four parts focus on areas including the 9 key health, safety and wellness investments for a high-performing organisation, rights and responsibilities. The third one will be workplace design, and fourthly, business practice. Now, this series is designed to leave business owners and managers feeling informed, inspired, and with practical takeaways to really make it happen in their business. So on to a bit of housekeeping then for today's session and how to make the most out of your webinar. You'll have the opportunity to ask questions as we actually at the end of the webinar by clicking on the Q&A menu item. There you can enter your question into the form and just simply click on send, and we will pass that on to our experts to answer. Speaking of experts, I now have the great pleasure of introducing our expert presenters for today's webinar, and that is Kara Reynolds and Joe Kitney. Now, Kara is a Senior Associate at HWL Ebsworth Lawyers. Now, Kara, firstly, a warm welcome as our guest expert for today's webinar session. And before we kickstart today's session, we'd love you to tell us a little bit more about yourself and your background.
Thank you, Katrina, and thank you for inviting me to speak to everyone today on this topic. It's an area that we are often advising in, given the complex array of not only legal obligations, but commercial and business implications. I'm a lawyer in the workplace team at HWL Ebsworth Lawyers. Workplace covers health and safety, employment, and industrial law. In the health and safety side of things, I generally assist businesses who have had an incident in the workplace, such as an injury or fatality. I investigate the incident and provide advice on the outcome of investigations. I work with the company in their responding to regulators, whichever regulator that may be. For example, Workplace Health and Safety Queensland, the Petroleum and Gas Inspectorate, Transport Inspectorate, or the Mines Inspectorate. On the employment and industrial side of things, I'm usually advising HR or management across any business sector. I draft and negotiate with employees and unions on enterprise agreements. I draft workplace policies and procedures and contracts of employment. We advise on all aspects of employment, such as redundancies, restraints of trade, confidentiality, and management of bullying and harassment. I've undertaken investigations into some extremely severe cases of bullying and sexual harassment and prepared reports to clients on their exposures and strategies with dealing with them in this regard. I'm often devising strategies for managing injured workers at work and assisting in settlement arrangements or other matters that proceed to court. Prior to becoming a lawyer, I worked at 2 different Queensland coal mines, which I think has largely shaped my industrial dealings, particularly with the unions. I thoroughly enjoy the diverse and hugely political and ever-changing laws that face workplaces, and I hope that I can give you some tips to take away today and put into practice in your own businesses. Thanks, Katrina.
Great, thanks, Kara. And now I've got great pleasure in introducing my highly regarded associate and co-organiser of this series, Jo Kitney. So Jo, can you tell us a bit more about yourself and your background?
Thank you, Katrina. I'm the Managing Director of Kitney Occupational Health and Safety and have about 20 years experience working across heavy industry, manufacturing, healthcare, education, maritime, and also local council and service industries, working both here in Queensland and also across Australia, and have a UK background. Prior to working and living here in Australia, I trained in occupational health in the UK and then transferred my skills over here into health and safety. Kitney Occupational Health and Safety, we provide health and safety services across a range of industries, and as well as construction and the industries that I mentioned earlier. As an OHS professional, though, what I have is a particular interest in due diligence, governance and management systems, and really tailoring services to meet legal and business needs. So this means being practical as well as pragmatic, understanding what the law requires, and then being fairly strategic and forward-thinking to find those business solutions. I've got a range of health and safety qualifications across OC Health and Safety and lead auditor qualifications for health, safety, quality and environmental management systems. In my spare time, as well as being a mum to 3 children, I'm a visiting teaching fellow with the London South Bank University and a chartered health and safety professional with the Safety Institute of Australia.
Thanks, Jo. And very briefly, a quick summary of my background. I'm founder and director of Wellness Designs, a boutique workplace wellness consultancy company. And in essence, we help Australian organisations create healthy, safe and high-performing workplaces. And we specialise in strategic consultancy, speaking and training services for workplaces, government agencies and industry groups. So we're proud to have worked in the field for over 20 years, delivering multi-award winning programs both nationally and internationally across a range of industries. So hopefully with this combination today of legal, wellness and safety expertise, you'll find this webinar not only informative, but hopefully leave you with some practical takeaways for your business. So let's get the ball rolling. So looking at today's webinar, we're really going to be delving into what are an employer's responsibilities for providing a safe workplace, work activities and managing workplaces. Then subsequently the workers' responsibilities for health and safety and fitness for work, and really how to strike that balance between these responsibilities. And the latter is often a case of the art and science, but being able to strike this balance will ultimately enable your organisation to minimise risk, to prevent and reduce the cost of workplace injury, to boost productivity, and ultimately create a great place to work, which is, I think, what we're all striving for. So now I'm going to hand over to Jo, who's quickly going to delve into some of the challenges facing today's workplace in managing health and safety and people at work. Jo, over to you.
Thank you, Katrina, and I'm really delighted to spend a few minutes talking about the business challenges, both in managing health and safety, but also health at work. And having worked in OC Health and Safety over the last 20 years, I know, and I'm guessing that those listening here will know also, that there are times when managing health and safety and people at work goes well, when the workplace and work activities are safe, when employers establish safe work processes and provide the right training and information for workers, and workers understand and take on board their obligations, follow these policies and procedures and the training that's provided by their employer, and they work safely. And additionally, they have the right levels of fitness to undertake their role. We also know that there are times, though, when managing health and safety and people at work doesn't necessarily happen, and that balance can get tipped. So not all employers, and particularly small business owners, have access to legal advice, and I'm really delighted that Kara from HWL Ebsworth Lawyers is here to join us. So what I'll do is just spend a few minutes talking about those business challenges and really set the scene for Kara to provide her insights and her expertise. When you actually look at the landscape of managing health and safety at work, there's no doubt that modern business works in a very different regulatory landscape than in the years gone by. And what you can see on the slide here are some changes from the iconic New York skyline back in 1932 through to a more modern day London of 2011. These two photos actually tell a really important story. So not only are we seeing that there's a changing landscape of the cityscape behind, but we can also see that it's a colour photograph for 2011, that the guys have got their hard hats, they've got their high vis, they've got some safety harnesses. You can just see those hanging down there from where they're sitting. And Katrina, you'll probably also notice that the guys are a little larger than they were perhaps back in 1932. But what this photo also tells us, and there's a story behind it, and it's my understanding that those that were involved in having the photo taken and took the photo were ultimately disciplined and removed from site. So that tells us that that regulatory landscape, both in terms of health and safety practice, but also the follow through in ensuring and enabling, and if necessary, disciplining staff within the workplace to follow those safe procedures, is the landscape that we're now working within. And similar to most countries in the world, Australia has introduced its work health and safety legislation as a way of establishing standards and managing hazards and risks. Sadly, of course, health and safety legislation is, for the most part, reactive. And when we read the legislation, it's always worth bearing in mind that sitting behind the requirements is generally an injury, an incident, a death perhaps, or an ill health that's been experienced by someone or a group of people, and that after all it is our workers on the front line that generally get injured and harmed when things don't go according to plan or well. So the extent of legislation and compliance with obligations is determined by the government based on those incidents and injury stats, research, and also pressure from workers and unions. So have a look at the changing skyline. We know, of course, that we're operating in a much more modern day work and legal framework. So just have a quick peek at some business facts and figures. And what you can see on the slide here is a changing landscape in Queensland and Australia also. So back in 2013-14, there were about 420,000 trading businesses in Queensland. Of those, 145,000 back in 2009 employed between 1 and 19 staff. So we know that the majority of businesses operating in Queensland are small or lower end of medium-sized. And in fact, back in 2012, in fact, it was identified as 96% across Australia overall. Sadly, the cost of work-related injury to Australian economy is somewhere in the region of about 61.8 billion. So it's a really significant cost to people, community, and to business. And about $8.4 billion worth of workers' compensation premiums were paid back in 2012-13. Prior to putting together the material for the webinar here, I had a look on Health and Safety Queensland's website just to look at the number of prosecutions that we've seen since 2010 And you can see the figures on there, 77 back in 2010 and 11, and 84 across that 2012, 13 and into 2015 period. So you can see that the regulator is fairly active, and it'll be interesting to hear from Kara about her experiences that are coming out of those prosecutions, particularly with the new harmonised legislation that we're operating under. And interestingly, 45 workers' compensation prosecutions since 2010. So of those 45, 44 of them were against workers who were fraudulent in the workers' compensation processes. So it's an interesting landscape that we're operating in, and of course sitting behind that is the health and safety legislation. Now, when I talk to businesses that we work with and others that we meet in industry, there are a number of common issues and challenges for both employers and workers. From an employer's perspective, I'm often told that health and safety legislation can seem overwhelming, and that when they do put in place health and safety, workers don't always follow their safe work processes or practices, that they may question why additional training is needed if staff already have qualifications to do the job, and what to do when workers don't appear to be fit. So they may be under, or appear to be under the influence of drugs or alcohol, perhaps experiencing a mental health condition or poor physical fitness. Flipping onto the other side of the coin, from employees, I'm often asked what they should do when perhaps the plant or equipment they're using isn't in good order, when they don't get time, they feel, to do the job safely, and they feel the need to take those shortcuts to get their work done. And perhaps when managers don't respond to requests for training and what they should do about their long working hours. So as a health and safety consultancy, we do endeavour to work with both employers and employees to establish good practices to push through some of those issues. And I'm always interested in hearing that legal perspective from Kara, just in order to help balance that pendulum between the employers and the workers. I'm sure that many of you will be familiar with the iceberg analogy that you can see on the slide here. But one thing I'm particularly interested in is how we can reverse the position and ensure that health and safety and workers and fitness for work is well managed. And anyone who takes the time to look at the costs of injury and ill health, whether this be in monetary terms, but also in terms of loss of life or livelihood and the impacts on workers and their families, will know that costs can absolutely be too high. And on the slide here, you can see just some of the direct as well as the indirect costs where health and safety management at work fails. So in terms of the iceberg analogy, the principle is that what sits above the waterline, the tip of the iceberg, we can often generally see and perhaps quantify, but sitting beneath the waterline as the lower part of the iceberg are things that are perhaps hidden, not accounted for, and often those can be of a much greater magnitude than the initial direct costs that we perhaps see as a result of poor health and safety management. There's an interesting background to the iceberg analogy here, and it actually came back from the Health and Safety Executive in the UK from research that they did in the early 1990s. And at the time they were looking at the cost of incidents and comparing insured versus uninsured costs. And what they established was that for every dollar or every pound in their research of insured costs, so that's the tip of the iceberg, there was somewhere between 8 and 36 pounds, and we would relate that to dollars, of uninsured costs that perhaps aren't accounted for through insurance premiums and cover there. So most businesses will find that whilst they may have their insurance in place, it will absolutely not cover the broader and wider costs of poor health and safety management. So for those who perhaps haven't seen it, on the Health and Safety Queensland's website, they do have an incident cost calculator, and it's always a very useful tool if you're trying to put an understanding around incidents or even potential incidents, so projecting forward, that may impact your organisation, particularly if you need to put business cases together or put an understanding around what the return on investment could be for putting in place good health and safety management or employee health management for fitness for work. And the link to that incident cost calculator is going to be provided at the back end of the slides here. So moving on into balancing the pendulum, I'd just like to raise one final point before moving over to Kara. One of the companies that Kitney Occupational Health and Safety works with is HMG Hard Chrome, which is a superb precision engineering business based just outside of Brisbane. Lincoln Gibbons is the CEO of HMG Hard Chrome, and from my many conversations with Lincoln, he absolutely always demonstrates his clear understanding of the links between health safety and health, people and health at work, and the return that can have on the quality of work that those workers do, and thus therefore achieving those business goals. And what I wanted to do here was to share with you one of my early conversations with Lincoln, and that was his clear understanding that lead time was a really fundamental that drives success for the business. So if health and safety is well managed, if incidents are prevented, and if he has staff that are in good shape and able to deliver on time, then the business is in good shape. However, if an incident happens or workers aren't able to deliver, then they're not able to meet or achieve their business objectives. So it isn't all about business objectives, but what this does do is connect up the relevance of both health and safety and fitness for work and that broader picture of business performance. So I'll hand over to you back to you, Katrina, and I'm really looking forward to hearing Kara's presentation. Thank you.
And thanks, Joan. Some really interesting insights into some of the challenges you're seeing your clients particularly face on the ground on a day-to-day basis. And now, Kara, following Joe's expert insights, really looking forward to you shedding some further light on some of these challenges from a legal standpoint. So over to you, Kara.
Thank you, Katrina. Managing safety and managing ill, injured and chronically absent employees is one of the greatest challenges for businesses. In every case, businesses are required to navigate a minefield of legal obligations and constantly weighing up legal risk with every move. The claim exposure to the business is significant. There's the Work Health and Safety Act, workers' compensation, general protections, discrimination both at a state and federal level, unfair dismissal, privacy, bullying, health records, Fair Work Act, breach of contract, breach of industrial instruments, and the list goes on. So today we'll be focusing on the safety and employment aspects, and therefore the legislation referred to on your slide. But it's a constant juggling act for employers to manage the various obligations. It's also difficult to know where to seek help. Is it appropriate to speak to a lawyer? Can you utilise your HR or safety professionals? Is it appropriate to seek an outside body, such as those offerings of Joe and Katrina, to provide assistance? I should also note that we've spent, just the other week, we spent an entire day on this topic, managing injured and ill workers in the workplace. So we've only got a short amount of time today, and I'll try to cover off on the key aspects. But the legislation is freely available for you on the web. So go and have a look and ask any questions if you're not sure. So we'll start with employer obligations. Under the Work Health and Safety Act, it requires a person conducting a business or undertaking, or a PCBU, to ensure, so far as is reasonably practicable, the health and safety of their workers while at work. So this includes through the provision and maintenance of a safe work environment, the provision and maintenance of safe plant and structures, the provision of safe systems of work, the safe use of substances, the provision of adequate facilities, the provision of any training and supervision, and to just generally ensure the health of workers are monitored for the purpose of preventing illness and injury. Under the Work Health and Safety Act, officers have a duty to exercise due diligence to ensure their organisation complies with work health and safety laws. An officer can be found guilty of an offence regardless of whether the organisation is found guilty. And in particular, the work health and safety laws, particularly under the new harmonised laws, impose a specific duty on officers to exercise due diligence to ensure the PCBU meets its work health and safety obligations. This is a new and proactive and positive obligation on all officers within a business. So I've assumed today that our webinar participants know and understand the due diligence obligations of officers, so I won't go through this in any detail, but if you do have any queries, please just contact us afterwards to discuss. So moving on to the Workers' Compensation Act. Employers must ensure workers are covered by insurance. In Queensland, this is generally through WorkCover. Some employers can obtain self-insurance, but it's quite difficult. Employers need to be working with work cover to assist in the rehabilitation and return to work of injured workers. And if a worker has a work-related injury or disease, employers can't use this as a reason to dismiss them within the first 12 months of them sustaining that injury or illness. Now, onto the Fair Work Act. This Act governs employees' minimum entitlements through the National Employment Standards. It's the main piece of legislation that governs employees' basic entitlements. It's read in conjunction with modern awards, enterprise agreements, relevant contracts of employment, etc. Under the Fair Work Act, employers must ensure they do not unfairly dismiss certain categories of workers. So this is all about ensuring you have a valid reason and you've offered the worker fairness in the termination process. So, for example, if you don't have adequate safety procedures and an employee acts unsafely, it will be more difficult for the employer to prove that they had a valid reason for that dismissal. And even if you do have a valid reason, you still must ensure that you're providing the details of the allegation to the employee and allowing them the opportunity to respond to those allegations. So don't act too quickly or on a whim when terminating a person's employment. Under the Fair Work Act, there is also the general protections and unfair dismissal provisions. So an employer cannot take adverse action against a worker by reason of the worker exercising a workplace right. So bringing that back to what we're discussing here today, a workplace right will include a worker's right to lodge a workers' compensation claim or the right to take personal leave. So even though we recommend employers are careful when terminating or dealing with employees because of safety and fitness issues, that doesn't mean that their hands are tied and nothing can be done. So moving on with the discrimination legislation. So over the past 30 years, the Commonwealth Government and state and territory governments have introduced laws to help protect people from discrimination and harassment. Commonwealth laws and state laws generally overlap, and they prohibit the same type of discrimination. As both state and Commonwealth laws apply, you must comply with them both, but unfortunately they apply in slightly different ways, so you'll just have to manage that when you find yourself with a claim. We notice in my work the workplace discrimination arising pretty much in all aspects of the workplace. For example, we see claims in the way in which employees are recruited or selected, discrimination in the terms or benefits offered as part of the employment, discrimination in the decision as to who will receive training and what sort of training is offered, and also in the selection for redundancies. So that's an overview for the employer's obligations, but employees also have various obligations under the Acts as well. Under the Work Health and Safety Act, workers must take reasonable care for their own health and safety, take reasonable care that their conduct doesn't adversely affect the health and safety of others, comply so far as is reasonably practicable with instructions, and cooperate with reasonable health and safety policies or procedures that have been notified to workers. In our experience, the Work Health and Safety Regulator, as Jo indicated earlier, is not likely to bring a prosecution against a worker. Other safety jurisdictions, however, are different. For example, the petroleum and gas industry and that inspectorate is more likely to bring a prosecution against an individual, and often the cases that we've had, they're bringing prosecutions against 3 or 4 or even 5 of those individuals involved in an incident. Under the Workers' Compensation and Rehabilitation Act, employees must participate in rehabilitation and mitigate loss, and if they don't, the insurer may stop covering them. And I might just digress here for a moment. There was a very recent Supreme Court case of Kennedy, which is a great example of where 2 areas of workplace safety and workers' compensation can become intertwined. In that case, the employee was working on a pipe, and when he opened it, chemical solution shot out and burnt his foot. Even though the court heard that the working area was poorly lit and there was a build-up of scale obscuring the valve's opening and closing symbols, the court reduced the workers' compensation entitlement quite substantially because it held that the employee failed to isolate the pipe in accordance with the company procedure, and that this is what fundamentally caused him to suffer the burns to his foot from the solution. So this case makes it clear that where an employer has a clear procedure in place, the workers will be obliged to follow that. And if they are not, they will be held to have contributed to the injury that they suffer. Just on that point, this is under the Workers' Compensation and Rehabilitation regime. If it was under the Work Health and Safety Act, in our experience, the prosecution would have been brought against the employer in those circumstances. even though the employee had some cause in the injury. So moving on to the discrimination legislation, employees must be able to undertake the inherent requirements of the position. So it's not unlawful to terminate employment on the basis of a disability if, because of that disability, the employee would be unable to carry out the inherent requirements of the position. Or in order to carry out those requirements, they would require a provision of services or facilities that would impose an unjustifiable hardship on the employer. So again, to provide you with a case example of what is an inherent requirement is the High Court case of Qantas Airways and Christie. In that case, Qantas had dismissed a 60-year-old international airline pilot on the basis of his age. In deciding whether the pilot could fulfill the inherent requirements of his position, the High Court considered it relevant to look at the surrounding context of his employment, as well as his physical ability to perform the task. As most countries prohibit pilots over the age of 60 from flying in their airspace, the court decided that the surrounding context meant that he was not able to fulfill the inherent requirements of the job, even though he was physically capable of doing so. So employees need to be able to perform the inherent requirements of their positions. Employers are required to consider adjustments in the workplace that could assist the employee to be able to perform those inherent requirements. But just how far does the employer have to go in accommodating the worker? Well, in answer to this question, the courts will look at each case on its facts to determine what's reasonable. So examples of what a court has not considered to be reasonable include the adjustment is just too expensive. It takes into account the business, whether it's small or large. Changing the inherent requirements of the job so that it would be altered or abolished is not required. It has been found to be not reasonable. Assigning performance of some of the inherent requirements to another employee, or creating a new or different job, or promoting or transferring to a different job. So it'll really be a case-by-case basis as to what the adjustment is and whether that's reasonable for the business to implement. So moving along, on this slide, we've just listed what we've noticed employers and workers do badly that gets them into strife legally from a work health and safety perspective.
And Kara, there's a great list there, both from an employer and workers' perspective. So where have you gleaned some of these from, some of these issues?
Yeah, thank you, Katrina. Really, this is just in our experience, the cases that we see come through our door, often with the work health and safety matters. It's serious incidents, so it's we only see them when it's a fatality or an amputation or a break or something like that. So it's not the a strained back or something like that, but these are the common problems that we see from the safety perspective. So for employers, they just simply don't have proper processes in place to manage safety or to discipline workers when they're working unsafely. Often it's just poor management. They leave injured workers out of the workplace and unmanaged for too long. And on the flip side, we see workers getting themselves into strife where they refuse to follow policies and procedures, such as having designated walkways that no one uses, including managers. Or the fact, in many safety cases, it's often an employee just trying to help out. They're undertaking a task that's outside their scope of work, and they're just trying to help everybody else out, get the job done a bit quicker, and that's when things go wrong and the incident occurs. So again, here I've just listed where we see things go wrong, but from an employment perspective rather than safety. So the problems here are employees are not being held to the requisite notification and evidence requirements for accessing paid or unpaid leave. And as I touched on earlier, employees are being allowed to remain on extended unpaid leave for too long without clear expectations of when the final stay or go decision will be made. We see employers failing to adequately explore reasonable adjustments that could be made to the role to accommodate illness or injury or for any redeployment opportunities. We often have matters where the employers have failed to be clear with employees about job requirements. And probably one of the most important points on the slide is employers failing to proactively manage the employee's capacity for work and seeking out current medical evidence. So we often find that these deficiencies just turn on a misunderstanding of the employer's rights and obligations. So what are the warning bells? When should the alarm start going off that you might be getting yourself into some hot water? Again, I've just listed a few there and I won't read them out. You can do that all yourselves. But with an injured worker, you might need to consider whether the injury is work-related or not work-related, obtain medical evidence and only rely on medical evidence that is current and relevant. Consider how long the employee has been off work. What reason do you have to terminate their employment? If it has absolutely nothing to do with the injury, so they've gone into a fight or they've breached a policy, then you need to act promptly, as you would with any other employee, and start the disciplinary process, assuming the worker is fit to engage in it. Check your employment contracts. What are your requirements with respect to termination and consultation? Make sure you're updating your employment contracts on a regular basis. So I think we've started to get into managing the risks now, so I'll move on to that slide. And again, I won't read this whole slide out, and it looks like a lot to take in, but really it's just good business process. I will point out that you need to be very careful with the policies and that they're not forming the terms of the employment contract so that they restrict the way that the employer can manage safety. So, for example, an employer may be restricted from unilaterally changing safety procedures such as a drugs and alcohol policy because the policies are a term of the employee's contract and they therefore need their consent to change the policy. So it'll depend on the wording of the contract and the way in which the policies and contracts are delivered to the employees. As a starting point, you should be reviewing all of your contracts of employment and policies to see where your obligations lie. We are often assisting clients in this, and most of our clients don't seem to have it right. So, as I said earlier, managing safety in the workplace and fitness of workers is a legal minefield. You need to ensure you have competent people within the business managing those exposures. You should be enlisting the assistance from specialist safety and wellness practitioners to ensure your safety systems and processes are effective. And get legal assistance early in the claims process so you can strategically plan your response and also work in with the HR team. Thanks, Katrina.
Thanks very much, Kara. So we've got a few minutes left now if you'd like to submit any questions to our expert facilitators, Joe and Kara, using the Q&A section on the Zoom platform. But while we're waiting for some questions to come through, Kara, I've got a couple, if that's okay. Can we ask your thoughts and guidance of where you've got health and safety policies in place, but they're not being followed by an employee, despite being asked on a number of occasions? So I guess what you can do in that situation. I guess the second part of that, in terms of reasonable process, and how many formal warnings could you give someone in that instance?
Okay, thank you, Katrina. So you've got your policies and procedures in place, particularly with the safety policies and procedures. You need to make sure that you're disciplining employees that aren't following them. Otherwise, you're going to find it difficult to discipline them when you do have a big safety incident. You also need to be careful with your policies and procedures that employees are being trained in them, that everybody knows what is contained in the policies and procedures, and that they're being enforced. When somebody's not following them, go down your disciplinary process. Make sure you're following the disciplinary policy when you're going down that process. Follow it carefully. There's no real rule as to 3 strikes and you're out and anything like that, unless it's written in a policy or procedure. Generally, it'll be determined on how severe the action is. So, if they've done something well, there's a recent case actually, and often the Fair Work Commission will uphold any dismissal in relation to termination of an employee for a safety breach. But there was a recent case, and the name escapes me at the moment, but it was a train. The train driver had sped 850 times on one route, and he'd also left his passenger, his co-worker, at one of the stations, and his employment was dismissed. The Commission said that whilst they are reluctant to intervene in these matters, that it saw the 850 times of speeding as being one whole kind of breach, and with relieving the co-worker on the station, it was an accident, and that he couldn't have known that she was there. He thought that she was still on the train, and for that reason, and because the co-worker didn't tell him to slow down, and there was no kind of action taken against her, it held that it was unfair and it was excessive in those circumstances, and he was reinstated.
Thanks, Kara. Not only that comprehensive answer, but really interesting case study as well. And just again, while we're waiting for a few more questions to come through, I've got another one here. If, as an employee, if they're turning up for work potentially under the influence of alcohol and drugs, or they're suspected of, what should an employer do in that case, Kara?
Thanks, Katrina. So ideally, you'll have a policy and procedure on drugs and alcohol in the workplace, particularly if you're in a workplace where it's high risk, and it'll allow you to test people under a reasonable suspicion. In any case, you can't have a worker that you don't believe to be safe in the workplace and creating risks to your other workers. So it really needs to be managed, and it's going to depend on kind of the business that you're in, and whether you've got these policies and procedures and how you can follow them.
If someone is off injured and off work on workers' compensation, can the employer terminate their employment in that instance? Could you respond to that, Kara? And then we've had a question come through which we'll turn to. Thank you.
Thanks, Katrina. Yeah, absolutely. It depends on what the reason is. So if the reason is in relation to the injury, and the injury is a workplace injury, then you can't do that within the 12-month period. And then outside of the 12-month period, you've got to be looking at that inherent requirements of the job. If it is just, for example, somebody failing to follow a policy or procedure, or they failed to follow a reasonable direction to attend a medical or something like that, then yes, you can. You follow the same process as what you would with any other employee. They've failed to follow a procedure. You need to make sure that they're fit to go through the disciplinary process, but certainly you can terminate their employment while they're on workers' comp. It is a little bit muddier, because they're going to have more. They might bring a general protections application. They might bring a discrimination claim. So that's why the business needs to be very careful that it is clearly documenting the reason for their termination and making sure that they're not breaching any of those obligations in coming to that decision.
Great, thank you, Kara. And I believe we have time for one question that has come through from Bruce. So do you involve government agencies in your day-to-day activities? And if so, at what stage do you involve them?
Hi, Katrina. I'll be delighted to answer that question. And interestingly, the questions come through from Bruce Shakira, who is a colleague of mine that I studied with 20 years ago in the UK when I did a health and safety OC health qualification there. And Bruce's background is actually not necessarily from the UK. And Bruce, forgive me if I get it wrong, but I have a feeling that you're either from Nigeria or Kenya. And so you moved over to the UK for your studies, and obviously are still based over there. So the question was, do you involve government agencies in your day-to-day, and if so, at what stage? So just to answer Bruce's question, but also to be clear about the role of the Health and Safety Queensland, and thus, in that respect, the government agency, Health and Safety Queensland has 4 key roles. It sets policy, so it establishes the legislation, it lays down the act, the regulations, the code of practice that we see within our legislative framework here in Queensland, and thus would be the same for the other jurisdictions across Australia. They also have an inspectorate arm. So if you have an incident, or if they have a right of entry even without an incident, to come onto your premises in order to investigate or to look through and to monitor that you're indeed meeting your obligations. The regulator also has a very important educational arm. And so on Health and Safety Queensland's website, there is an absolute array of education and videos and various other materials that your business can absolutely tap into, from young workers right the way through to asbestos management. And they also have a prosecutory arm. And so where an incident occurs, and if they feel that there's a need to establish the a prosecution, they'll then go forward. So that's the 4 key arms of the regulator. And we've just had a quick text through from Bruce, and it was from Zimbabwe. So my apologies, Bruce. Katrina, I'll hand the question back to you.
Great, thanks Jo, and hopefully we've got time for one more question, and this one's directed at Kara. And the question is, how can a business protect itself potentially from a false workplace injury claim? This person is currently paying for an employee who admitted to injuring himself at another workplace. However, WorkCover has accepted his injury claim because he had a medical opinion stating the injury most likely occurred at our workplace. Any thoughts around that, Kara? No.
Yes, thank you, Katrina. And this is a really difficult one. Look, what you need to be doing is getting your own medical evidence. It's really difficult in the workers' comp regime that we have in Queensland, because if you don't have evidence to the contrary, it's difficult to find these fraudulent claimers. So what we do when we get involved, and unfortunately we are usually involved in these type of arrangements, if you're able to get, if somebody is injured but you've got your suspicion that they're able to do more things than that they say they do, we often get investigators onto them to see what they're doing in their day-to-day life. But in this case, you really are going to be bound by the evidence. So you need to be getting some medical evidence to support your position. Otherwise, there's not a lot you're going to be able to do with that.
If I could just also contribute into the answer there, Kara, from a practical health and safety perspective, if you can also demonstrate that indeed you had your policies and procedures in place, that you were able to demonstrate that indeed there were safe work practices, and can demonstrate or indicate that it would be highly unlikely for that incident to have occurred or the injury to have occurred within the workplace, that can also support the medical evidence. I'm assuming that from a practical health and safety perspective, that would add to the weight of evidence from a legal perspective that you may well be able to use in your defence.
Absolutely. So that's exactly right. And the best way to do this is to be getting in early. So if you're able to get in before the work cover stage, the employer can make their case, say why they don't think that it's right. Then if you can get it knocked out at that early stage, it's a lot cheaper for the business. The next stages that you're going to be going down is having to run a hearing and having evidence, and it's going to depend how the evidence falls in court. So that'll be really dependent on what the court decides on the day, unfortunately.
Great, so thank you, Kara and Jo, and I think that brings us to the end of our question time and also very quickly to the end of our webinar. So what I would like to do now is just to look at where to from here. So for those that are looking for potentially some further information on the back of today's session, we've listed at the end of our presentation here some useful resources that you may want to check out. Things around state legislation, also the Workplace Health and Safety Queensland site, which obviously has a wealth of information, including the injury cost calculator that Jo referred to earlier, and a small business checklist as well. And there's also here some great resources just generally also for small and medium business, including areas such as health and wellbeing, sites such as Heads Up and Business and Mind. So certainly worth, again, delving further into those. So as far as our future seminars, we hope you can join us for the remaining 2 sessions in our Healthy, Safe, Productive series. The next session will actually be a breakfast seminar. It's about making the right choices, the easy choices, and how smart workplace design for a safe, healthy and productive workplace. And we're going to be having, again, 2 industry experts joining us for that session. It'll be Sarah Pazell, who's an occupational advisor and human factors and ergonomics specialist from the Viva Health Group, and Melissa Marsden, who is director and workplace strategist of Marsden Collective. So again, if you would like to join us for that next session, if you just visit the Healthy, Safe, Productive website, and we'll be finishing up the series with a Beyond the Silo session, how good business practice and a collaborative approach to workplace health and safety and wellness are critical to business success. So again, registration's opening shortly for that one. So if you'd like to contact any of the presenters from today's sessions, we've got the email, mobiles, and also website addresses for the respective presenters. I'm sure they would like to continue the conversation. And just to finish up, on behalf of the Healthy, Safe, Productive team, we'd like to thank you very much for joining us for today's webinar. We'd also like to extend a heartfelt thank you to our expert contributor for today's webinar, Kara. So thank you again. We hope the webinar confirmed that when you put the right thing with the wise thing, that it's going to equal the smart thing for your organisation. And most importantly, we hope you'll walk away with some practical tips on how to strike that balance in your organisation. And also, just to do a final thank you as well to Business Depot, our sponsor for today's session. So as far as final housekeeping, so we can continually improve our level of service, we would really appreciate you if you'd stick around, just complete the short survey at the end of the webinar, and hope to see you at the next one. Thank you very much.